Federal courthouse in Oakland, California. Elon Musk takes the witness stand and accidentally confesses to something nobody saw coming. He's suing Openai in federal court, accusing his former co-founder Sam Altman of stealing a nonprofit charity and converting it into a for-profit empire. Then the defense lawyer asks one question about xAI, the plaintiff's own artificial intelligence company, and he admits, under oath, that xAI trains itself on OpenAI's models. The man suing for principal is borrowing the defendant's homework. This is BillionCipher. This is the moment that flipped the biggest AI trial of the decade. The case is Musk versus Altman, OpenAI, and Microsoft. It opened in late April 2026 in the Ronald V. Dellums Federal Building in Oakland, California. The trial is being heard by Judge Yvonne Gonzalez Rogers. The jury is 9 people, 6 women, 3 men. Their verdict will be advisory, which means the judge ultimately makes the binding ruling on liability. Elon wore black, crisp suit, dark tie. He was combative from the first question. OpenAI's lead lawyer, William Savitt, walked him through a series of timeline questions. The world's richest man accused Savitt of lying. He accused him of asking misleading questions, of trying to trick him. They raised their voices. People in the gallery shifted in their seats. Then Savitt got to xAI, the artificial intelligence company Musk founded in 2023, 2 years after the bait and switch, he says, broke his trust in his old co-founder. The same outfit that makes Grok, the chatbot he markets as the alternative to ChatGPT. The same company whose parent now sits at a $33 billion valuation after absorbing X, the social network formerly known as Twitter. Savitt asked, in essence, does xAI use OpenAI's models? Musk said yes. What he admitted was that his startup uses a common AI industry shortcut. You take a more powerful model, you feed it prompts, you record its outputs. You use those outputs to train your own competing model to behave the same way. The industry calls this distillation. It's one of the most legally and ethically contentious practices in artificial intelligence right now. OpenAI's own terms of service explicitly forbid using its models to build competing products. So when the founder of a competing product admits, under oath, that he's doing exactly that, the moment lands hard. According to trial coverage from MIT Technology Review, there were audible gasps in the room. Now think about what just happened. The man whose entire legal argument is that OpenAI betrayed the public by becoming a for-profit had just confirmed that his own private company is feeding on OpenAI's research to compete with it. He was, in real time, demonstrating the exact dynamic he was suing to prevent. He did this in a black suit, under oath, on a Tuesday. That's not how a trial is supposed to go for the plaintiff. To understand why this moment matters, you have to go back to 2015. OpenAI was founded that December as a nonprofit research lab. The stated mission was that artificial intelligence should be developed openly and safely for the benefit of humanity. Not for shareholders, not for billionaires, for humanity. Elon co-founded it. Sam Altman co-founded it. Greg Brockman co-founded it. Ilya Sutskever co-founded it. Musk committed to bankroll the early work. By his own account, he put in tens of millions of dollars. He sat on the board. The project's purpose, he told reporters publicly, was to keep advanced AI out of the hands of 1 or 2 companies. Hold that line in your head, because in 2017 and the year after, the co-founders started arguing about money. Building artificial intelligence at the frontier turned out to require billions of dollars in computing resources, not millions. A nonprofit dependent on donations was never going to compete with Google or Meta. The founders began debating different corporate structures, from for-profit conversions to capped profit hybrids. The talks collapsed without a clear resolution. In February of 2018, Musk left the board. When Altman took the witness stand last month, he described that exit as a desertion. "We were kind of left for dead," the Openai CEO testified. He said his old co-founder's departure caused employees to worry about funding. He said some of them feared the world's richest man would seek vengeance. The following year, Openai created a for-profit subsidiary. They called it a capped profit company, with returns to investors limited and the original nonprofit still holding control. They needed the structure to raise serious money. Microsoft showed up first, with $1 billion in 2019. Then ChatGPT launched. The product detonated. Hundreds of millions of users in months. And in early 2023, Microsoft committed an additional $10 billion. The company's valuation surged into the hundreds of billions. That's when Musk says he lost trust. He texted Altman directly, "What the hell is going on? This is a bait and switch." 6 words that became the foundation of a federal lawsuit. But the message is more complicated than it sounds. Because while Elon was sending it in early 2023, he was also founding xAI. He incorporated his competing AI company in March of that year. He started recruiting researchers. He started raising capital. Some of those researchers came directly from Openai. That timeline matters because in a separate text, dated February 18th of the same year, Altman wrote back to his co-founder, "I'm tremendously thankful for everything you've done to help. I don't think that Openai would have happened without you." The defense pulled that message up on a courtroom screen during Altman's cross-examination. The plaintiff's lawyer, Stephen Molo, asked the Openai CEO if he still meant it. Sam said his view on Elon had changed significantly. Molo pressed harder. Did the witness just say things he thought people wanted to hear? The answer was no. He had complicated feelings about his old benefactor. Then the lawyer cut him off. Walk through the years that followed. By April of 2024, xAI was running. In November of that year, Musk filed his second lawsuit against the company he had once helped fund. In February of 2025, a consortium led by him made a formal offer to buy Openai outright. The price was $97.4 billion. The board rejected the offer in days. They said the company was not for sale. 2 months later, xAI acquired X, the social network Elon had purchased for $44 billion 2 years earlier. The combined valuation came in at $33 billion for his AI business. The deal allowed the startup's valuation to be shared with X's investors, which conveniently dragged the social network off the world's richest man's personal balance sheet as a standalone money pit. Now read all of that as one timeline. The man who left Openai's board in 2018 sued the company in 24, offered $97.4 billion to buy it the following year, was rejected, went to trial in 26 to argue that the company had betrayed its founding mission. And the same year, his competing AI company, founded immediately after he says he lost trust, was already using the defendant's models to train its own product. That's the context the jury is now sitting with. Back to the present. The trial took 3 weeks. Closing arguments concluded Thursday, May 14th. The jury starts deliberating Monday, May 18th. Their verdict is advisory. Judge Gonzalez Rogers will issue the binding ruling on liability afterward. The legal question is narrow. Did Altman, Brockman, and Microsoft engage in a breach of charitable trust when they reorganized Openai from a nonprofit into a profit-capped commercial entity? The plaintiff's lawyers argue yes. They argue Elon donated his money and reputation on the express promise of an open public benefit project. and that the for-profit conversion violated that promise. The defense argues the opposite. They argue Musk was inside every meeting where the for-profit structure was debated, that he proposed his own version of a for-profit conversion in 2017, and that he left when he could not control the outcome. They argue, through Altman's own testimony, that Elon walked away from the nonprofit when it was struggling and then came back to sue it once it became valuable. That's the case in front of the jury. Now layer in the XAI admission. The moral framing of the entire lawsuit depends on the idea that Musk is the principled co-founder, watching with concern as his old company sells out the mission, suing not for damages, but for the public good. Defender of the original nonprofit ideal. The admission complicates that frame. If your own AI company is being built in part by training on the outputs of the company you're suing, your role in the lawsuit gets harder to defend. You have a direct financial reason to slow the defendant down. That changes what a principled lawsuit looks like. It starts to look like one billionaire's attempt to handicap the company most likely to beat him to general artificial intelligence. That's the read Openai's lawyers spent 3 weeks building. And it's the read that the plaintiff himself, in a black suit, under oath, in front of an audience that audibly gasped, helped them construct. Now, we wait. The advisory verdict could come this week or next. Judge Gonzalez Rogers will then issue the binding decision on liability. After that, a separate remedies phase begins, where the court determines what, if anything, Openai has to change about its corporate structure or its operations. The question this trial doesn't answer is the one underneath everything. If AI is going to remake the global economy, who should own it? A handful of trillion-dollar tech firms? A repurposed nonprofit that turned into one of them? A consortium of billionaires fighting over it in court? Or someone else entirely? We don't have an answer yet. The jury starts work Monday. If you want the case file on every story like this, the receipts, the timelines, the courtroom moments other channels miss, subscribe to BillionCipher.